Welcome to Widener University Commonwealth Law School. I am Andre Cummings, the Dean of this exceptional place, and I am very excited to welcome you to the Gedid Lecture this year, 2025. John Gedid founded the Law and Government Institute, was one of the pillars of our law school and community here, continues to be a fantastic supporter of the law school and the Law and Government Institute. We celebrated our 25th year anniversary last year at the evening at the Capitol, lovely event, and I was really honored to be able to honor John Gedid that evening for his leadership and for what he's created with this terrific institute. And I am really delighted to be standing next to Jill Family, who is the faculty advisor of the Law and Government Institute. And I want to shout out Rob Teplitz, who directs the institute incredibly well. And I really wanted to give Jill the opportunity to share about the Institute, about the lecture, and then we'll have Ben McFadden come up and introduce our speaker, Ron Levin, who we're very excited to have here from Wash U in St. Louis. Jill.
Thank you. So as Dean Cummings said, I'm the faculty advisor of the Law and Government Institute, but I had the pleasure of starting my work with the Institute under John Gedid when he was the original director of the Institute. So it's my pleasure to sort of keep that continuity going and especially to be a part of this lecture, which honors all that he's done for our law school. So the Law and Government Institute is one of our signature programs here at the law school, and it focuses on the complex intersection of legislation, regulation, public policy, and the law. And the Institute has three main objectives. One is to help students earn specialized certificates at graduation. The second is to contribute to the development of government law through the work of both our faculty and our students. And the third is to host public programs like this one that explore and debate important topics of government law. And as we know, this one honors John Gedid, who played such an influential role in the founding of the law school in general. He was the founding vice dean of this law school, and as we know, also of the Law and Government Institute. And he's here with us this afternoon via Zoom, so he is watching.
Hey, John.
So the idea behind this lecture is that we wanted to highlight the work of a nationally recognized scholar in government law every year, in much the same way that Professor Gedid was so dedicated to highlighting the work of his colleagues and our students. And so this is an annual lecture that we hold every spring. So a few housekeeping issues before we begin. We're recording this program, and your continued participation in the program is your consent to being recorded. There is a Pennsylvania CLE credit. If you're on Zoom, a link to a form to fill out to get your CLE credit will be available, I think, in the chat, but also should be emailed to you probably tomorrow as well. There will be some time for questions at the end of the program, both in person and over Zoom, so we'll be monitoring the chat for questions from online participants. So at this point, I'd like to ask Ben McFadden to come up to introduce our speaker. Ben is a third-year student who will be graduating this May with a certificate from the Law and Government Institute, and he serves as president of the Law and Government Student Society here at the law school. Ben.
I wanted to start by saying thank you, Professor Family, Dean Cummings, and the Law and Government Society for letting me speak today. It is my honor to introduce Professor Ronald M. Levin, the William R. Orthwein Distinguished Professor of Law at Washington University and St. Louis Law School. Professor Levin specializes in administrative law and has published widely in that field. He has also testified before the U.S. Congress on regulatory reform issues and participates actively in the work of the American Bar Association and the Administrative Conference of the United States. Before joining the law facility at Washington University, Professor Levin clerked for Judge John C. Godbold of the U.S. Court of Appeals for the Fifth Circuit and practiced for 3 years in Washington, D.C. with the firm Sutherland, Asbill, and Brennan. Professor Levin's lecture is titled The Limits of Loper Bright. Well, please welcome Professor Levin.
Good afternoon, everybody, whether you're here or in cyberspace. I want to thank the Law and Government Program for inviting me to speak to you, and I appreciate Ben's introduction. Now, my written bio says that I have written widely in this field. He stated it as he has written wildly in this field, which I consider an improvement as a gloss. Anyway, I want to thank Rob Teplitz and Jill family and others who have devoted so much energy to organizing this event. They made it easy for me to get ready at every step of the way. And I'm especially pleased to be able to give this year's John Gedid lecture on law and government. In contrast to many of the past speakers, maybe most, I've known John Gedid for a long time, in fact, about 15 years. We worked together to produce what became the 2010 Model State Administrative Procedure Act. It had a 7-year gestation period. John was the original reporter for the document back in 2003. By the time I joined the working group in 2007 as advisor from the American Bar Association, he had passed the reporter's baton to someone else, but he stayed as a member of the drafting committee. So we participated together in countless conference calls and live meetings to review and rework and revise the developing draft of the MSAPA. I think I can fairly say nobody was complaining that the meetings were not numerous enough. But through this sometimes lively and sometimes tedious process, John was always informative and patient and gracious. And after the act was completed, he hosted a symposium of participants and outsiders to discuss the act. And that was how I came to visit this campus for the first time. In short, John and I have had a lengthy association, and it's a privilege to be able to speak at a lecture series named for him. So now let's talk about Loper Bright Enterprises versus Raimondo. As all of you probably know, Loper Bright overruled the case of Chevron against NRTC, a precedent that for about 40 years had required courts to review agency decisions with substantial deference on issues of law. And the dominant reaction to Loper Bright has been that it's like an earthquake, a dramatic and transformative event. And that premise has given rise to endless speculation about what this reshaped landscape might mean in various fields of regulation. More specifically, it's contributed to a narrative that suggests that agency power will be dramatically reduced and the court's role dramatically enhanced as part of the Supreme Court's large campaign to weaken the administrative state. Well, that narrative has been reinforced by several other cases recently decided, and in regard to those cases, I largely agree with the conventional narrative. But I am among a minority of scholars who have suggested that the significance of Loper Bright itself is somewhat overstated. It's obviously an important decision, deserves much of the attention it has received, but I want to emphasize the ways in which it may be less of a break from the past than the dominant view suggests. And in this connection, I happen to have a perspective on Loper Bright that I share with almost nobody, because I've been writing about the principles by which courts review agency decisions on issues of law for more than 4 decades, that is, before Chevron came along. This came about because of a legislative proposal known as the Bumpers Amendment, which would have entirely abolished judicial deference on legal issues. It gained quite a bit of momentum politically in the period between 1979 and 1983. And so I wrote some studies about this proposal and related issues for the ABA Administrative Law section and later for the Administrative Conference of the United States. And this became a focus of my scholarship for the next several years. Now, the reason I bring up this ancient history is that many commentators seem to have trouble envisioning what administrative law could possibly look like without Chevron. But I don't have that problem because I actually remember what it looked like. And the truth is, it didn't look terribly different from the Chevron regime that succeeded it. There were differences, sure, but also plenty of continuities. After all, the whole point of the Bumpers Amendment controversy during the years that immediately preceded Chevron was that the courts were already displaying quite a bit of deference toward agencies' legal interpretations, to some people's minds, too much. So with that as background, let's get more concrete about the Loper Bright case and the Chevron rule that prevailed prior to this decision and the court's reasons for abandoning that rule. Loper Bright grew out of the Magnuson-Stevens Act. And as I'm sure you all know, that act is a law that governs fishermen who harvest herring along the Atlantic coast. And you also probably all know that it expressly provides that owners of fishing vessels have to allow government observers to ride along on their fishing trips in order to ensure that the fishermen comply with their obligations under the statute. But the act doesn't say who has to pay the salaries of those inspectors, the government or the fishing companies themselves. Well, the National Marine Fisheries Service, which administers this act, published a regulation specifying that the companies have to pay, which had not been the practice before. And the companies challenged the regulation in court. 2 circuits upheld the regulation, and the Supreme Court agreed to review those decisions. Now you're probably thinking, why was the court interested in that case? These fishing companies were actually not crusaders for administrative law reform themselves. But there's a lengthy report on this background in the Washington Post telling us that the real moving force behind this litigation was a conservative think tank, the New Civil Liberties Alliance, which is funded by the Charles Koch Foundation and other donors on the political right. They were looking for a case that would serve as a good vehicle to take to the Supreme Court in order to ask it to overrule Chevron. So they approached the fishing companies and offered to finance an appeal to the court, and the fishermen were happy to accept that offer. Anyway, the reasoning of the 2 circuits was that the act was ambiguous on the payment issue, but the agency's interpretation was not unreasonable and therefore had to be upheld. That reasoning made the case is a perfect illustration of how the Chevron doctrine worked. Under Chevron, if the authorizing statute in a regulatory case took a clear position on the precise issue involved in the case, the court and the agency would both have to follow it. But if the statute turned out to be ambiguous on that issue, as in this case, the reviewing court was expected to accept the agency's interpretation if it was reasonable. This test was often described as resting on a presumption that a statutory ambiguity was equivalent to a delegation. In other words, the court should presume that Congress would prefer for this ambiguity to be resolved by the agency and not by the court. Now, in Loper Bright, the court decided to abandon this long-standing presumption for a variety of reasons. First, and most fundamentally, the court said interpretation of the laws has been regarded throughout our history as the responsibility of the judicial branch since Marbury v. Madison, and Chevron prevented the courts from fulfilling that responsibility. Second, the court said Chevron was inconsistent with the Administrative Procedure Act. Third, the Chevron presumption was a fiction anyway, not based on a realistic assessment of congressional intent. And fourth, according to the court, Chevron impeded courts from adopting the best interpretation of the statute. I'm going to come back to that point a little later. There were also separate opinions, including concurrences by Justices Gorsuch and Thomas, and a dissent by Justice Kagan, who was writing for herself, and Justices Sotomayor and Jackson. But for my purposes, I'm going to focus on Chief Justice Roberts' majority opinion. And first, I want to discuss the court's claim that Chevron is incompatible with the APA, the Administrative Procedure Act. In developing that argument, Roberts relied heavily on the statement in the opening sentence of Section 706 of the APA that the reviewing court shall decide all questions of law. In my own scholarship prior to the court's decision, I took issue with that proposition. I argued that the opening sentence of the section did not say anything about how courts should decide such cases. It didn't say they couldn't rely on deference principles. And the drafters of the act themselves never displayed any particular attention to issues of judicial deference on administrative interpretations of law. And nearly all courts and commentators had appeared to assume in the immediate wake of the act and in ensuing decades that the first sentence of Section 06 had nothing to say about the manner in which they should resolve those questions. In her dissenting opinion in Loper Bright, Justice Kagan took essentially the same view, relying on part on my article and an amicus brief that I and other scholars had filed in the case. But for better or worse, that view did not prevail in Loper Bright. The court rejected it, and I will not try to relitigate it in this lecture. But I do want to say that the APA doesn't do much work in the court's substantive analysis. Basically, the court interpreted Section 706 as recognizing what was established law at that time. In Chief Justice Roberts' words, the APA incorporates the traditional understanding of the judicial function under which courts must exercise independent judgment in determining the meaning of statutory provisions. And in the footnote of the opinion, he candidly acknowledged this point. The dissent observes that Section 706 does not say expressly that courts are to decide legal questions using a de novo standard review. That much is true, he writes, but statutes can be sensibly understood only by viewing text in context, and the notion that some things go without saying applies to legislation just as it does to everyday life. Well, if the APA just replicates pre-existing law, why is the court going into this? In a way, it's not surprising that the court would have chosen to defend its decision to overrule Chevron on the basis of purported congressional direction. Over the years, the court has repeatedly resorted to essentially fictional claims that the principles it uses in reviewing agencies' legal interpretations have been prescribed by Congress itself. That rhetorical strategy was prominent not only in the Chevron doctrine, but also in related opinions, including U.S. versus Meade Corporation, Kaiser v. Wilkie, and recent decisions on the major questions doctrine. Some of you may know some or all of these cases. And moreover, in this particular case, this rationale would have distinct advantages for the court in terms of optics. Given that the court was determined to overrule a longstanding precedent like Chevron, it evidently preferred to characterize its holding as obedience to positive law instead of acknowledging that the recently installed conservative majority was choosing to substitute its own preferences for those to which the court had adhered for the past 4 decades. But anyway, whatever the court's motives for relying on the APA may have been, the substance of its reasoning doesn't seem to be very different from what it would have been if the court had never mentioned the act. The APA issue turns out to be something of a distraction, or perhaps I should say in this context, a red herring. So in the remainder of this lecture, I'm not going to have much to say about the APA as such. Instead, I'm going to turn to the principal thesis that I want to develop, that the effect of Loper Bright is to eliminate the Chevron presumption while making no other changes in administrative law doctrine. For that reason, I will sometimes refer to this thesis as the reset theory. The holding takes us back to where judicial review doctrine stood just before Chevron came along. Now, I don't want you to take the metaphor of reset too literally, because entirely apart from the question involved in Chevron and Loper Bright, administrative law on judicial review agency action has changed in some obvious ways during the past 40 years. For example, we've seen important case law developments regarding the major questions doctrine and the judicial hard look and hour deference and post hoc rationalizations and so forth. But my main point about the reset thesis is what Loper Bright does not do. It doesn't require significant adjustments in administrative law other than the abandonment of the Chevron presumption. In my view, that's the most straightforward interpretation of the opinion, but other scholars have read it more broadly, possibly because they're making assumptions about what they think the court must have in mind as opposed to what the opinion actually says. But I'm going to argue against those readings in this presentation. And as support for my thesis, I'll rest on 3 main propositions. First, the overall tone of the opinion is mild and legalistic and not particularly rhetorical. Second, as the court itself emphasized, Congress often does purposely assign policy-making responsibility to agencies. Judicial recognition of these delegations can compensate to some extent for the disappearance of Chevron. And third, the court also highlighted the court's traditional practice of giving respect or weight to administrative interpretations, a practice that's generally known as Skidmore deference. The continuation of that pattern will also serve as a partial replacement for Chevron. In fact, Skidmore deference carried significant clout in the years prior to Chevron, as the Bumpers Amendment controversy illustrated. We could infer that it may return to that role in the post-Chevron era. So now let's consider these propositions more closely. First, as to the tone of the opinion. In the years leading up to Loper Bright, the conservative movement issued many calls for Chevron to be overruled, and these calls were frequently bombastic and rooted in a generalized antipathy toward administrative agencies. And that spirit is reflected to some degree in the polemics against Chevron that Justice Gorsuch had published repeatedly, both before his appointment to the Supreme Court and afterwards. But it was conspicuously absent from Chief Justice Roberts' majority opinion, nor did Roberts say anything to endorse the idea that Chevron was unconstitutional, which Justice Thomas had asserted years earlier and repeated in his concurring opinion in Loper Bright. Instead of relying on these ideologically freighted premises, Roberts based his opinion on a relatively narrow doctrinal foundation focused on the principle of independent judicial judgment. He said the courts have not been doing their job as fully as they should have, but he cast few, if any, aspersions on the agencies themselves. So the upshot is that although some observers may think of Loper Bright as containing a meta message of antipathy toward agencies extending beyond the abolition of the Chevron presumption, they won't find that proposition articulated in the majority opinion itself. Now I want to turn to my second proposition supporting the reset thesis, which revolves around the concept of delegation. As Chief Justice Roberts explained in Loper Bright, that concept is reconcilable with the general principle that courts must interpret regulatory statutes using independent judgment. As he wrote, in a case involving an agency, of course, the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. When the best reading of a statute is that it delegates discretionary authority to an agency, the role of the reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress, subject to constitutional limits. The court fulfills that role by recognizing constitutional delegations, fixing the boundaries of delegated authority, and ensuring that the agency has engaged in reasoned decision-making within those boundaries. Now, that reasoning may be easy to accept in the abstract, but not everyone agrees about how far it should extend. In Loper Bright, Roberts did not press the argument as far as he might have. He focused on some of the easiest possible illustrations of his thesis, including cases in which the congressional delegation was explicit or was obviously contemplated by open-ended statutory language, such as appropriate or reasonable. Ellen April, a professor at Loyola Law School, has inferred from those illustrations that Loper Bright's teachings about delegation apply only in those narrow circumstances. But the court itself did not endorse any such limiting principle, and in contrast to Professor April's position, I'm going to argue for a reading that cuts in the opposite direction toward breadth and not narrowness. The court's line of reasoning can be extended to encompass numerous cases of implicit delegation without distorting any essential feature of the court's model. And as I'll explain, this extended model contemplates that congressional delegations to agencies are pervasive, but they're also limited. First, as to pervasiveness, a few years ago, a study by two political scientists, Pamela McCann and Charles Shippen, concluded that 99% of all major regulatory statutes that Congress has enacted in the past 7 decades have contained some delegations. And the conclusion that I draw from that finding is that although Loper Bright tells us that a court may not presume that ambiguity is equivalent to delegation, a court will often be standing on sound ground when it relies on the particular facts and circumstances to infer an actual delegation, intended delegation, but implicit. To that extent, I tend to agree with Adrian Vermeule's suggestion that by focusing on the issue of delegation, courts may be able, under Loper Bright, to achieve at retail what Chevron previously enabled them to accomplish at wholesale. However, as I said earlier, these pervasive delegations are always limited. Congress is not in the habit of issuing blank checks. And as the language that I quoted from the Chief Justice recognized, the courts always play an important role in fixing the boundaries of the delegated authority. So litigants might show that a statute categorically forbids what the agency did, or they might contend that the agency applied the wrong framework of analysis, or that it considered a factor it was not allowed to consider, or failed to consider a factor that it was required to consider. The courts have to mediate all those arguments. All these types of arguments were well defined in the case law before Chevron came along, and so there's every reason to think that they'll be back at full strength now that Chevron has been overruled. Now, I don't want to leave the impression that I expect that all or most students of administrative law will immediately rally around the delegation-centered model that I have just outlined. Many scholars argue that in between the realms of pure law and pure policy, there's a middle ground, often known as the realm of mixed questions of law and fact. And they maintain that courts have broad discretion to classify questions in that intermediate zone as involving either law or discretion, and commentators have spent decades jousting about the merits of various approaches in that vein. However, the Loper Bright opinion, as I read it, does not sound especially receptive to this type of analysis. It doesn't mention mixed questions at all, except in its historical survey. The court seems to have bought into the idea that courts have the entire responsibility to resolve questions of law, except insofar as they can find that Congress has assigned responsibility for such an issue to the executive branch. I'm not saying that courts will not or should not take account of policy considerations as they define the boundaries of judicial review. But if we can judge from the tenor of the Loper Bright opinion, they'll need to characterize those factors as bearing on the extent to which the issue at hand was delegated to the agency. Despite the strained, if not fictitious, nature of that mode of discourse, it may be a necessity in dealing with a court that often seems to prefer formalist reasoning over wide open judicial balancing. And now I turn to the third proposition underlying my thesis, that Loper Bright prescribes less of a sharp break from the Chevron regime than many people have assumed. Here I focus on the court's approving references to the so-called Skidmore Doctrine. This is a doctrine under which reviewing courts have traditionally given what Loper Bright calls respect or weight to agency interpretations of statutes they administer. To some extent, this practice can make up some of the ground that abandonment of Chevron has surrendered, but I want to spend a few minutes exploring the extent to which this could occur. The doctrine takes its name from Skidmore versus Swift and Company, a classic 1944 Supreme Court case written by Justice Robert Jackson, as paraphrased by Chief Justice Roberts in Loper Bright. The court explained in Skidmore that the interpretations and opinions of the relevant agency, made in pursuance of official duty and based on specialized experience, constituted a body of experience and informed judgment to which courts and litigants could properly resort for guidance, even on legal issues. The weight of such a judgment in a particular case, the court observed, would depend on the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it the power to persuade, if lacking power to control. Now, the cases in this line of authority routinely acknowledge, as Loper Bright did, that the court is the final authority on statutory interpretation. It's not required to accept the agency's views. But the point of the doctrine is that the agency's view should be seriously considered. There's no consensus in the case law about just how to apply Skidmore. Many of the differences are discussed in a leading article by Kristen Hickman and Matthew Kruger, and I'll rely on their analysis in a somewhat simplified form. They distinguish between two versions of Skidmore. A relatively weak version is what they call the independent judgment model, although I have to hasten to add that their use of that term is entirely different from the way that Loper Bright uses it. Under this conception of Skidmore, courts should uphold an agency's views only to the extent that they find those views persuasive. But Hickman and Kruger also describe a second, more robust version of Skidmore, which they call the sliding scale approach. Under that approach, courts will generally give weight to an agency's views, but their power to persuade in a given case depends on contextual factors such as those mentioned in the Skidmore opinion itself: consistency, thoroughness of consideration, and so forth. The author's survey of lower court cases applying Skidmore found that 3/4 of this sample preferred the second sliding scale methodology. And I think internal evidence in the Loper Bright opinion indicates that the Chief Justice Roberts also intended to endorse the stronger version of Skidmore. He based his argument not only on the Skidmore case itself, but on precedents stretching back to the early 19th century. Overall, he referred to the Skidmore principle 5 times, which certainly suggests a deliberate decision to highlight it. And I was especially struck by the Chief Justice's observation in Loper Bright that Congress expects courts to show due respect for the views of the executive branch. The phrase due respect seems to imply that a particular judge, let's say a judge who is generally mistrustful of administrative agencies, could in principle be faulted for not displaying the respect that is due. Presumably litigants, other judges, or members of the public could cite a lack of due respect as one reason to criticize that judge's ruling. To be fair, however, I should mention a brief passage in the Loper Bright opinion that, if read broadly, would seem to cast a bit of doubt on the court's reaffirming of Skidmore. It showed up in the context of Roberts' explanation of how a reviewing court should respond to an ambiguous statute in a world in which the Chevron presumption has been abolished. He wrote that instead of declaring a particular party's reading permissible, as Chevron might have allowed, courts use every tool at their disposal to determine the best reading of the statute and resolve an ambiguity. Well, so far so good. That remark would seem to follow directly from the holding of Loper Bright. But in the next sentence, Roberts went on to say that in an agency case, the best reading of the statute is the reading the court would have reached if no agency were involved. At least at first glance, that sentence is troubling because it appears to exclude any meaningful role for deference to agency views, even Skidmore respect. And yet the very point of the Skidmore doctrine is that it will, and sometimes should, make a difference in the court's resolution of questions of law, even though the court is the final and authoritative decision maker in such cases. At least one Court of Appeals panel in the Fifth Circuit has acknowledged puzzlement regarding the apparent tension between Skidmore and the court's best reading language. But for my part, I believe that the court did not mean to endorse the full implications of this concept of the best reading as the reading the court would have reached if no agency were involved. Chief Justice Roberts offered no explanation or justification for it, and he cited to only one source, footnote 11 of the Chevron opinion. Yet that language in its context actually supported the opposite proposition. More specifically, footnote 11 stated that in deciding whether to defer to an agency's interpretation, the court need not conclude that the agency's construction was the reading the court would have reached if the question initially had arisen in a judicial proceeding. And moreover, we can be pretty sure that when Justice Stevens included the footnotes language in his opinion in Chevron, he didn't think of it as saying anything original. He was simply quoting verbatim from a 1946 case, Unemployment Compensation Commission versus Aragon, which was issued the same year the APA was enacted. And furthermore, the court had, between then and the time of Chevron, quoted and followed that sentence many times, as well as afterwards. In short, the sentence from Aragon has been a recognized principle of judicial review throughout the entire modern history of administrative law. Indeed, when it is quoted correctly, the sentence merely states what ought to be self-evident. The concept of deference would have no meaning if it didn't sometimes lead to a different result than would have ensued if no agency were involved. So in light of the rather shaky foundations of the best reading language in the Loper Bright opinion, I tend to think that courts should apply it in a manner that harmonizes with the court's unmistakable adherence to Skidmore. And they could do that by simply adhering to a slight paraphrase of the court's own words. When they encounter an ambiguous statute, courts should use every tool at their disposal, including Skidmore factors, to determine the best reading of the statute and resolve the ambiguity. But now I want to home in on the question of the extent to which Skidmore may serve to offset the demise of Chevron. Here it'll be helpful to return to Hickman and Kruger's metaphor of the sliding scale. They use that image in order to emphasize that to some extent the courts become more or less willing to uphold an agency in a particular case depending on how the various Skidmore factors played out in that case. So in the lower end of the scale, where the Skidmore factors weighed against the agency's interpretation, that interpretation would result in little or no support for the agency's side. But at the high end, where the factors preponderated in the agency's favor, the court would, as Hickman and Kruger's article put it, accord distinctly Chevron-like deference. So if that pattern shows up in future cases, we can expect that the court's application of Skidmore weight will resemble the former results of Chevron deference in some cases, but not in others. Or to put it another way, the judge's acceptance of an agency's views in a given case may be reminiscent of Chevron if they conclude that the Skidmore factors point in that direction. The choice would rest in their hands. But some courts and commentators may object to this application of Skidmore, and they may argue that because the court did, after all, overrule Chevron, it apparently believed that judges have been letting agencies get away with too much, and so the court should apply Skidmore in a skeptical spirit, a more skeptical spirit than they would previously have displayed. As I've been suggesting, I interpret the Supreme Court's opinion differently. I understand it to mean that although agency views do not bind a court, they generally do merit consideration, and courts should accord those views due respect. So to sum up what I've been saying up to this point, I see the elimination of Chevron deference as essentially a reversion to judicial review doctrine as it stood in the early 1980s. I don't mean to imply that the court's holding will make no difference. Reviewing courts will not be able to look at a problem to say to themselves, oh, that's complicated, and immediately conclude that the agency's position should be upheld if it's reasonable. They will have to consider whether the agency's view can be seen as an exercise of delegation, or if not, whether the interpretation deserves Skidmore respect. But I don't think Loper Bright necessarily requires courts to reach outcomes that are less friendly to agencies than they could have reached under Chevron. I want to close this presentation with just one dose of realpolitik, because I've been discussing Loper Bright on a purely doctrinal level. But of course, judicial review is not shaped only by doctrine. In all probability, agencies will encounter a less agency-friendly environment in the near future than they did in the 1980s, not because the prescribed standards of review are different, but because The bench is now populated by many judges who are more skeptical about regulation and the administrative state than the typical 1980s judge was. In fact, I would have made that same prediction even if Chevron had not been overruled. I also recognize that the court's subsequent decisions in the future will put their own gloss on the teachings of Loper Bright. The scope of review of agencies' legal rulings is different from most administrative law issues in that the court is constantly making new pronouncements on the subject numerous times every term. Administrative lawyers face the task of distinguishing genuine changes of direction from disparities driven by the idiosyncratic features of individual cases. And in that sense, the doctrine in this area is and always will be somewhat in flux. But even so, I expect that the Loper Bright opinion, as written, will continue to exert an unusual degree of influence and be viewed as a leading case, just as the Chevron opinion continued to exert influence for decades after it was decided. As judges with viewpoints that are relatively friendly toward the administrative state hear some cases either in the short run or long run, they will find that Loper Bright allows them more latitude to rely on agency interpretations than the conventional wisdom supposes. Thank you for your kind attention.
Does anyone have any questions? While you're thinking about that, and if while we check the chat, I'll kick it off with a question. And I think you touched on this a little bit at the end, and I hope your answer to the question will be yes, it would be too cynical. Would it be too cynical to say that it's not really the test that matters as much in this current environment as much as the outcome that a particular test may produce?
Oh, well, I think cynicism is always worth considering. And I think that courts constantly keep policy considerations in mind, whether it be the policies reflected in the statute itself or their own personal agendas. I don't think it's cynical to think that that will happen. But I think there also are cases where the judges are not that invested in the outcome. We're not talking about the headline cases where we can foresee an ideological split way in advance. But some of these, I think they're just looking for the legally respectable answer because either they're not invested in it or they need to reach agreement among their colleagues. And to do that, legal reasoning seems like the most credible way to do it. So I think the answer is sometimes that sure there are cases that you can see a mile away are likely to result in very predictable answers, but not always.
Thought I saw a hand back here. Yeah.
Thank you. Thank you, Professor Levin, for your lecture tonight. I feel very vindicated by hearing you say a lot of these things. This summer, I was very fortunate and I'm very grateful to have had the opportunity to have worked for a state agency this past summer. And when Loper Bright was decided, my chief counsel encouraged me to read it, and we talked about it, and I feel very much the same way that you do, in that it may not be as earth-shattering as many people feel that it is. And I was curious what your thoughts are on how that will impact state agencies. And it seemed the environment this summer was that it may have a strong impact. Some feel that it may not, and I was curious what your thoughts are.
I don't think we should dismiss the possibility of self-fulfilling prophecies. And because people have read that that Loper Bright is a big deal, and things are going to be so different. They're going to take that message and bring it to their individual cases, and the prophecy becomes self-fulfilling. They now think that they have a much tougher standard of review to apply. I wouldn't dismiss that possibility at all, but different people bring different takes to a given case. And in a way that means that it's the job of counsel to frame it in ways that best suit their clients. And for agency counsel, that would mean saying, wait a minute, it doesn't exactly say that things were terrible before and they're going to be totally different now. You have to frame it and try to be as persuasive as possible.
Other questions? Did I see a hand? No. Oh, Professor Family.
So I'm wondering if you see any intersections between Loper Bright and another phenomena that seems to be growing in terms of, the growing executive power and unitary executive theory. And if you think that Loper Bright, however it's interpreted, can serve as sort of a check, because, even if it's not as strict as even if it's not as strict as it could be, right? Even if your argument is correct, it still has to represent something different from Chevron. So I'm wondering if you think that this, like an increased role for the courts, could serve as some sort of check on an increased assertion of power from the executive branch.
Well, the courts always have a role as part of their institutional position to think about checking the executive branch. And the unitary executive theory has some lessons about some issues in terms of what the executive has power to do, that is vis-a-vis other branches. But there are other cases where it plays less of a role because the choice is simply between what the agency has to say and how the court analyzes the statute and the like. So I think I don't want to extrapolate too far from just saying the executive is always going to win under both of those analyses, right? But at the same time, when power shifts from one administration to the next, judicial review principles often flip. And people who are the strongest defenders of agency power during one administration become the strongest critics in the next administration. And the few humble academics like myself and a few others who aspire to articulate consistent principles that you can apply both ways, we're one voice, but there are other voices that may resound more loudly. So you see a lot of variety in that regard.
There's a comment in the chat from someone who has been practicing administrative law since the 1980s, saying that their view is consistent with yours from that experience. Based on what you said at the beginning of your remarks, I think you had said that your view is in the minority of the scholars who've evaluated Loper Bright. What has, other than just having a different view, what has the response been to your thesis?
Well, I wish there was enough attention to my thesis for people to have a response. But what I meant in that context was on the superficial public image level. I'm not talking about how scholars who examine it closely or practitioners who examine it closely have reached conclusions. And we're still getting various takes from different directions. I was only saying that the view I want to put forward today is different from the popular conception of Chevron, which I think is to the effect that the court has turned the world totally upside down. And that gets exaggerated in the context of translating pretty technical doctrines for popular readers. I don't fault the reporters. They do what they can to explain it, but it just, a lot of nuance gets lost in the process. And so the immediate reaction to Loper Bright was, oh my God. And I did articulate a different view soon after it was decided in a column that CNN asked me to write. So it got some attention, and I got some people saying, yeah, I think that's what the opinion says, not what everybody thinks it says. But those messages get lost quickly because this is a case that affects so many different areas of regulation and of interbranch relations that you constantly have people talking about it. And a lot of those are based on, what I say is the image rather than having studied this really lengthy and complex opinion closely.
And we have a question in the chat. How do you factor in changes in the way that the court approaches statutory construction, and in particular, how in the last 40 years the court has moved away from looking at legislative materials and some substantive rules of construction?
Well, they have. And that affects how they approach the APA. And it also affects how they read individual regulatory statutes. And I think all people who practice regularly before the court are cognizant that the justices have some very strong preferences about statutory interpretation methodology that are not the same as they were a generation ago. It's largely the influence of Justice Scalia, but I think the current acolytes of textualism and originalism carry it further than he did. It's become something of a notion that people are supposed to pledge allegiance to. And so when Justice Barrett wrote a well-known concurrence in the student loans case, she tried to explain that she was a textualist, even though the principles she was setting forth did not sound very textualist to me. Is just a premise that people believe they're supposed to follow. And they believe it because the justices do adhere to it. But I think this may pass. But always practitioners have to keep in mind what kind of arguments judges will be receptive to and not receptive to. So when I wrote my article about what the meaning of Section 706 of the APA, I was trying to be very cognizant of different argumentative styles. So I tried to give a comprehensive view of all the arguments that would be brought to bear to show that Section 706 requires independent review. And I got a couple justices' votes, but not enough.
We have time for one last question before Professor Family closes us out.
So thank you all for coming, and please join me one more time in thanking Professor Levin for traveling to be with us and sharing his knowledge. And we hope to see you soon at another Law and Government Institute event. And thanks so much for coming.